Welcome to today's video. Let's break down the Indian Contract Act, 1872. This law is the backbone of contractual agreements in India. We'll focus on some must-know sections to simplify your study. First up, Section 2. This section provides definitions that are crucial for understanding the Act. Terms like proposal, promise, consideration and agreement are all defined here. Think of this as your glossary. Moving on to Section 10. This section tells us what makes an agreement a contract. In simple terms, for an agreement to become a contract, it must be made by the free consent of parties competent to contract, for a lawful consideration and with a lawful object, and is not expressly declared to be void. So, if any of these elements are missing, it's not a contract. Next is Section 11. This section explains who is competent to contract. In India, a person must be of the age of majority, which is 18 years, of sound mind, and not disqualified from contracting by any law. So, your 17-year-old cousin cannot legally enter into a contract. Section 14 is about free consent. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. If any of these elements are present, the consent is not free and the contract could be voidable. Now let's discuss Section 25. This section states that an agreement made without consideration is void, unless it is made out of natural love and affection, or is a promise to compensate someone who has voluntarily done something for the promiser, or is a promise to pay a time-barred debt. Remember, consideration is something of value exchanged between the parties. Section 56 is also important. It deals with the doctrine of frustration. If an act becomes impossible or unlawful to perform after the contract has been made, it becomes void. For instance, if a concert is cancelled due to unforeseen circumstances, the contract to perform becomes void. Lastly, Section 73 deals with compensation for loss or damage caused by breach of contract. It says that when a contract is broken, the party who suffers from the breach is entitled to receive compensation from the party who breached the contract. The compensation should be for any loss or damage which naturally arose in the usual course of things from the breach, or which the parties knew when they made the contract to be likely to result from the breach. And there you have it. These sections are crucial for understanding the Indian Contract Act 1872. Grasping these basics will help you navigate more complex contractual issues with ease. Thanks for watching. Don't forget to like, comment and subscribe for more simplified legal content. Catch you in the next video.